I published a little booklet called The Real Law. And however, you don't have to be here to get a copy. All you have to do is go to 1215.org. Okay. You click on enter 1215.org website, and that's just a temporary page because the next page is the true page. No, it isn't. Is that the true page? No, I don't think so.
I scrolled down to get to the front.
Oh, I remember.
Now it's on the promotions of the event.
Right.
You scroll down.
You click there,
Oh, just click there. Either way.
and that takes us to the home page. And so when the temporary page disappears, this is what you'll see. On the right-hand side, you'll see where it says booklet for your information. And that's a PDF file. It's an exact copy of the booklet. So everybody can have a copy if they want, print it out on paper or something. And but it covers, it does a broad brush view of the of what the legal system is about. So I'm going to bring that up. Because the real law, in fact, the word law without qualification in the Constitution means common law. So under the common law, well, the common law supersedes the equity law anyway. When you look at the history, well, not the history. When you're looking at information about the law, you come. I think it's section 22.2 of the California Civil Code. I think that's where it is. It says that basically the rule of decision shall be the common law unless there is a code that overrides it. And I want to explain that because, as I've been saying, the common law is the higher law. The best way to understand that is this. If I go to your house and I visit you, if I want to use the bathroom, I'll ask your permission. Because when I'm visiting, I'm under the law of the domicile. In other words, your own law, how you control your own house. If you visit my house, then you have to ask permission because you're now under the law of my domicile. So whether your law supersedes or my law supersedes depends on which house you're in. So it's the same thing with common law and equity law. If you file a lawsuit using equity law, then you're in the equity house, and therefore it will override the common law. If you're in the common law house, then it overrides equity law. So it all depends on whose house you're in. And you control that by how you write your paperwork, which is what we'll get into tomorrow. But I'm letting you know today that there is that difference. So if there's an actual head-to-head collision between common law and equity law, then the common law will supersede. Okay. Now, an interesting thing is that when you're in the common law house in what's called a court of record, then the court of record, like I said, supersedes, and the decisions of a court of record are not appealable. Very powerful kind of thing. And also, in a court of record, the decisions of a court of record carry a presumption of validity. a decision in an equity court does not carry a presumption of validity. So what a lot of people don't realize is if you have a common law case and you ended up in equity court, since the equity court decisions do not carry a presumption of validity, you can open up a brand new case under common law and start all over again. So you'll go to court and you'll see the courts are always issuing, what do they call them? Like a memorandum of law, but that's not it. Why can't I think of it? I had a very good lunch, and now I have brain fog. Minute orders. They always issue minute orders. Well, why do they issue minute orders? Well, first of all, let me explain the word minute. Everybody says minute, but it's actually minute. Because in ancient times, and this is where it's good to know your history, in ancient times, when a judgment was issued, it was written by hand, because they didn't have typewriters, okay, in a large hand. On the other hand, the clerk kept notes, and those notes were written in a minute hand, meaning small. So you had big writing and you had little writing. So the big writing was used on the judgments, the little writing was used on the clerk's notes. So what happened was that when the United States was formed, one of the things they did in the Judicial Act of 1783, was it, or something like that? I don't remember. Or was it 89? Whatever it was. When they issued that Judicature Act, excuse my mispronunciations here, they combined the equity courts and the law courts. But the thing is that the highest law of the land is supposed to be the Constitution. So the equity courts and the law courts are treated separately in the Constitution, so they could not, under the Constitution, put the two courts together and make it all one. So what they did instead is they said, well, okay, we'll just have one room with both courts, and the same judge is sitting in both of them. They don't teach the difference, so attorneys don't seem to know the difference, and the judge is free to switch back and forth between the two kinds of courts, and people don't really know what court they're in, whether it's a law court or an equity. Don't know what you're talking about. Oh, you're saying like it'd be nice to have a little light so you know? Yeah, that would be nice if you had a little light up there, and yeah. So the way they get around it is they brought in this idea of minute orders. Okay, clerk's notes. That's all it is. A minute order is not an order. However, because of our ignorance, we think it's an order, and as long as everybody thinks it's an order, well, then it gets enforced. Okay, but the truth is, it's not an order at all. An order, and this is court decisions in the past, an order has to be written, it has to be signed by the judge or somebody who's in authority, and it has to be filed with the clerk. All three conditions. Okay? Minute orders are not orders. They're identified as minute orders. That means they're clerk's notes. Now, we don't have large hand and small hands anymore, or minute hands. So everybody writes the same size on a typewriter. So therefore, a minute order is distinguished by its name, and even in the writing somewhere. But Yeah. So I've done this a lot of times. I've done a counterclaim or filed a brand new lawsuit despite what the equity court said. And I just point out, hey, that minute order is not an order at all. It's a clerk's note. That can be very useful if you have a totally unfair proceeding and you really want to push. You can bring that in. So, and you look it up, and it's in the law dictionary. It describes what an order is. I don't know if it has a minute order in there, though.
On Black's Law?
Yeah.
So it's basically a non-binding, non-enforceable order, in a sense, right?
Well, everybody agreed to it, so unless somebody raises the issue, it's going to be treated as an order. They put people in jail. Okay. Well, I guess they do. I haven't examined the record that closely, but you're in court, minute order is an order. But only if everybody accepts it. So that somebody knows and starts objecting on that basis, well, then now they have a problem. Because constitutionally speaking, the equity court and the law court are two separate kinds of courts, two separate kinds of procedures. And a court of record proceeds according to common law procedure. Now notice that I said common law procedure. The procedure is what you're following by common law. So on that basis, I'm getting brain fog again. That was a good lunch. So anyway, let's go through this book a little bit because it's I like to think it's informative. Modern law is civilized warfare. Pure and simple. Okay? You're somebody, if a nobleman comes with his army onto your castle's front lawn, you can't say, I'm not ready. You got to go out and meet him in battle.
Can you bring your scepter in the court?
Sure. Give him a good laugh. Okay, so, by the way, the word civilized, what does that mean? Civilized means you're going according to Roman law. You've heard of Roman civil law, perhaps? Okay, well, when the English nobility went out, when the English nobility went out on missions, what they did is they introduced people to Roman civil law. So before I go any deeper on that, let's just take a look at this little booklet. Okay, here's a table of contents. So it's kind of gives you an idea of what it's about. So we'll skip down here to a little history. You see, here we go. Starts off with, for our purposes, in 753 BC, that's when Rome got established. And there were 7 kingdoms before it became a republic. Okay? So that was a long time that they were there. It was 27 BC when it became a Roman republic. So all those years, 23 years, it was actually a kingdom. And it started off that the two brothers that established Rome, they had a disagreement, but they solved it. One killed the other. And that's how they did things in those days. And things haven't changed too much because I have a little book called about, it has to do with the history of Europe or history of England. It's a very small book. but every single page in that book is painted in blood. I mean, it's brother against sister, sister against brother, kids killing parents, parents killing kids, you know, all in wrestling for power. So that's kind of how things developed. But anyway, Rome became a republic at 27 BC. Then in 43 BC, or no, AD, in 43 AD until 409, you know, that's almost 400 years of domination over England. And they introduced the Roman law in England. But the thing is that England had its own, no yawning allowed in this court. Anyway, England was under Roman law. But the thing is that they had their own law. And, well, I take that back. At that time, they didn't. They were under Roman law. So then what happened was that Rome, in anticipation of the United States of America, decided to let foreigners in. And they actually had generals in the army, the Roman army, that were really barbarians. So they had split loyalties, you might say, and eventually the barbarians took over. And so that would happen at about somewhere during the 400s. So, and the barbarians introduced a new concept. Whereas Rome was a republic, the barbarians brought in this concept of the divine right of kings. In other words, the king was in his office because of God. God put him there, and he speaks for God. Okay? So obviously he's a very holy person, and he was also head of the church. So, but that concept of the divine right of kings, the king couldn't do anything wrong. If he did something wrong, it just meant he changed the law because he was the source of the law. It's kind of handy for the king. Eventually, that concept wore out because people, just common sense, could see when there was an injustice and the king did something that wasn't really acceptable. So, but you couldn't sue the king because, again, if he broke the law, it just meant he changed the law for the moment. So they introduced a new concept, a special court. Like if you're on the here in the United States on the state level, you would go to the risk management department. That's actually a court in the executive branch. Okay, it's not in the judicial branch, and they get first crack at your lawsuit. So if you go to sue the government, before you can file your lawsuit against the government, you have to go to the executive branch and give them a chance to fix the problem, whatever the problem may be. And so that was called risk management. On a higher level, such as like the federal government, we have what is called the Court of Claims. It's the same idea. You're saying that, well, the court did something, or the executive branch did something wrong, therefore they really should cover it, even though the law doesn't support that. So back in this era, 400 to 700, whatever, when they brought in the divine right of kings, they also brought in the idea that, hey, this is really not a good thing the person did. So without admitting guilt, they decide that, well, maybe the king should pay, or the government should pay. And that's your court of claims on the high level, and the risk management on the low level. Then, along about the 793, the Vikings showed up, and they did their own damage. But they were very interesting because, you see, the Roman Senate made the laws for Rome, but they couldn't enforce them directly. They went through what was called a praetor, Praeter. I think that's how it's spelled. The praetor was really the ancient sheriff. He did the function that our sheriffs are supposed to be doing, which is he stood between the government and the people. And he also had a certain amount of power. He could make up some of his own rules or laws. And so that was in Rome's time, the equivalent of our sheriff. Because our sheriff, as some of you may know, our sheriff can tell the federal government to get out. He can keep them out of the county if he chooses to. Okay? And in some cases, it's actually happened where the sheriff has told the government, look, if you have a warrant for somebody's arrest, you have to see me first. And I may or may not allow you in. So the Vikings came in, and unlike the barbarians, they felt that power came from the people. And so they elected their king. So so you had these three systems of law now in England. So the Vikings brought in the concept of the jury. So when the United States declared its independence and created its court systems, they had these three systems to contend with. You have the barbarian system of the divine right of kings. You had the Roman system of, limitations of governmental power with an intervening person, such as a sheriff or praetor. And then you had the Republican system, the Republic brought in, which basically says that power comes from the people. So restating it, the barbarians had power from the top. The Vikings had power from the bottom, from the people, and the Romans were kind of in between. And so each time that one of these major forces took over, what you had was a problem that the force that took over did not have the personnel. They had to hire local personnel in order to run the system. So when the barbarians conquered Rome, they tried to take force, and I think one barbarian was worth 3 Romans in terms of pecking order. But when they took over, they didn't have enough people to run. Rome was a big empire. So even though a barbarian general broke the rules, and because the military was not allowed within the gates of Rome, he did it anyway. And of course, power always beats law. Okay? So so you had that mixture there. When the barbarian government wanted to enforce something, they had to enforce it through Roman citizens. And of course, the Roman citizens, anybody who's ever been a manager knows how difficult it is to get people to obey the orders. They always get modified, they drag their feet or whatever. So that was the problem that they had. And then when the Vikings took over, they did not take over Rome, but they did take over England, the Great Britain, the British Isles. And so, same problem. They took over, but there are not enough Vikings to take over all those people. So they had to rely on the people cooperating. maybe they enforced it with fear or something like that. But so we inherited three systems from them that way. Now, what happened was that in 1215, you may have seen that number before. In 1215, that was the emergence of the British culture. That was the Magna Carta. So King John was basically doing battle with France, and he was conscripting the personnel of the nobility, and he was also taxing them because he needed money to pay his soldiers. And they got fed up with it, so they caught him in Runnymede by the River Thames, and they made him an offer. They said, if you'll sign this little document we got here, we won't cut your head off. So he went ahead and signed it, and then they went and to the Pope, and they got the Pope to bless it. Now, neither the king nor the Pope had any intentions of honoring this Magna Carta, but they were too politically weak to say no. So they signed it, but then they figured they might make their way through it. But what really happened was that within about a year and a half, both of them died. I don't know if it's natural causes or what, but they passed away, and the new king and the new Pope did not have that same solidness, same establishment that the old Pope and the old king did. As the nobility was still well organized, and so what they did was they went back to the new king and they went to the new Pope, and they got them to recertify and re-bless the Magna Carta. So the Magna Carta got pretty well established as a result. So it's considered fundamental to our whole legal system. Okay? Then, from 1215 to 1297, that's about 82 years, I think, 81 years, it wasn't perfect. There were problems. So King Edward I came along, and he passed what's called the Confirmatio Cartarum, or translating it into English, that means a confirming charter or confirming letter. And what that did is that established the Magna Carta as the common law. So because of his order, if a defendant demanded that the Magna Carta be treated as the common law, it had to be according to that order. Okay. Now that Confirmatio Cartarum was the bridge from England to the United States of the common law. Because we took the whole system in, and the American Constitution specifically says that all obligations that preceded the Constitution are carried forward into the present Constitution. So most people think that's like a mechanism to get the bills paid. In reality, there are a lot of obligations that had to be honored. So the American Revolution cast off everything except the law. And what was interesting is that when, I think it was Alexander Hamilton, signed the Declaration of Independence, King George reacted, and he canceled all the charters. So there were no legitimate colonies in existence. Theoretically, we had no law. So for a while, it was the grand juries that ran the country. They would issue the orders on what was due, and everybody at that time was well educated in common law. So that made it work. You cannot have common law if you don't have educated people. So here were people who knew. So in 1776, We had the common law of England, and we also had the Constitution, and we also had the beginning of the deterioration of the system. Because from the very first day, there were people that resisted it. So that's a kind of a brief description of what's in that little booklet. Then we come across this concept of sovereignty, which I explained before. We are all kings and queens here, unless you choose to be a citizen. And to help you choose, they don't tell you. They don't educate you, okay? But until after the Civil War, about 1868, there really wasn't any formal definition of being a citizen. But the 14th Amendment came in. So when you look at sovereignty, now this is not the same thing as a sovereign citizen. Okay, sovereign citizens are master slaves. In reality, you can have a sovereign citizen, but the problem is that the word citizen is context sensitive. In other words, what context is the word being used? Because if you're a citizen, you could be in your sovereign capacity, or if you're the other citizen, you'd be a slave. And so what they did is they fixed that problem with the 14th Amendment. So the 14th Amendment says, and I'm shortening it considerably, it says, if you're born or naturalized in the United States and subject to the jurisdiction of the United States, then you are a citizen of the United States. Then they turn around and say, are you a citizen of the United States? And you say, yeah. And they say, well, thank you very much for granting jurisdiction over you. See? So it's very handy to have people be citizens, and of course they don't teach people about being people. But there are court cases, and they're on the website, where the court has said that you can be a citizen for some purposes and not a citizen of another purpose, other purposes. Now to illustrate how that works, I used to have a friend who was a manager of the computer department of a bookstore, very large bookstore. And over time, he noticed that the janitor who went around sweeping the floors and emptying the trash cans, that sort of thing, he noticed that people in the employees generally respected him, treated him courteously, and so forth. Well, eventually, he found out that that was the owner. The janitor owned the outfit. So the janitor would, he had a boss, but anytime he chose to, he could step out of that role as a janitor and fix things if he felt it was necessary. So, yeah, he's an employee in one sense, but he's the owner in another sense. So you have a similar thing here. In one sense, you're one of the creators of the country. You're a member of that club. You're the people. The people are sovereign. But in another sense, you're a slave if you're a citizen. Okay, you're at the bottom of the pile. Because, you see, as a citizen, you don't have any rights. The Constitution says so. The Constitution says that if you're born or naturalized and subject, then you're a citizen. So you can't be a citizen if you're a sovereign. Okay, so you're in one status or another. But anytime you choose, you can break out of the mold and not be a citizen. Instead, you could be a sovereign, one of the creators of the country. So that can be very useful. Now, I'll tell you how it can be useful. You can open your own court. Okay? If you're one of the creators, the Supreme Court of the United States is your creation. Okay? Now, you weren't personally there, but you're a member of the club. If you're one of the people, you're one of the owners of the country. Okay? And as one of the owners of the country, you're entitled to change things when necessary. The change is limited. You cannot, even though you're in your sovereign capacity, you cannot tread into the territory of another sovereign. Do anything you want as a people, but don't injure a sovereign, another people. Now, citizens have no rights. What they have is privileges granted by the government. Now, they don't want you to realize that. So these privileges are all renamed, okay? They have a special name. They're called civil rights. That's what civil rights are. The granting of privileges by the government. And of course, the government can take them away if it chooses to. Okay? Of course, if they take too many away, then it might create a political problem. Okay? Start losing elections. You got zapped by the light. Didn't work. But that's okay. So, so now what they do, they turn it around. Are you a citizen of the United States? You bet I am. Well, then you're now subject to the privileges. Now, the Supreme Court, over time, has decided which of these privileges are protected by the Bill of Rights. Now, they're still not rights, but they are protected by the Bill of Rights according to the Supreme Court. But don't be confused. You have no rights as a citizen. If you say you're a citizen, they'll say, thank you very much for granting jurisdiction. Well, they may not say it that clearly, but that's what you do when you say you're a citizen. So, well, anyway, let's see. Continuing on here, we got the preamble. Let's analyze that. It says, we, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. Okay, long list of tasks. Okay, laundry list. Do ordain and establish this Constitution for the United States of America. Well, let's break that into pieces here. First of all, who are we? Well, we're the people. Where'd we come from? The United States. Okay? Why are we here? Well, we have a list of jobs to be done. And who is the beneficiary? The posterity. Our posterity is the beneficiary. Okay? And so, with all that, we do ordain and establish this Constitution for the United States of America. All right? Now, the thing to understand is that what you have here is every basic element of a public trust. You have the trustor, that's the people. We have the trustee, that's also the people. Okay, because we're running things, really. And who's the beneficiary? Our posterity. There you have it, the three things. And then you have a job definition. Okay, we list the jobs. That's part of every trust, what the duties of the trustee are. Okay? And so, for that reason, they established the Articles of Incorporation, which we call, in this case, the Constitution. So, the United States of America is actually a public trust. It's not a country at all. The true countries are the states. Now, the states don't have a president, okay? Corporations have presidents. Countries have governors. That's how you can know. And so each state here in the United States is a separate country. However, for certain common purposes listed in the Constitution, they came together. And so now the states, in one sense, retain their identity, but in another sense, they kind of gave up some of their rights. They have what's technically known as a clipped sovereignty. So we've put limitations on the states. I'll give you a good example. In the Constitution of the United States, in Article 6, there's a statement to the effect that regardless of any constitutional provision, regardless of any law, or regardless of any state constitution or any federal law, all judges are subject to the Constitution. So they're not exempt. A lot of people are exempt, or organizations are exempt from the Constitution, but not judges. They're covered 100%, whether they like it or not. So that can be a pretty good argument if you've got a dictatorial judge with a real attitude. You can hold them to the Constitution, whereas you might not be able to hold a state to the Constitution. See? So now the Founding Fathers realized that they didn't cover all the bases, so they brought in this Ninth Amendment. And it says here, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So the Constitution does not grant rights at all. It acknowledges rights. Your rights existed before you were born. Okay? All it does is acknowledge it. And so also the Constitution restricts the government. And you see, they're saying right here in the Ninth Amendment that just because we didn't mention what your rights are, that does not give the government permission to override your rights. Your rights pre-existed the Constitution. And you can bring in the Ten Commandments on that if you want to. That's a kind of a listing of rights. You know, you should be safe from murder and robbery and so forth. So, okay. So the Constitution is considered a restrictive document. I also want to mention one other thing. And a lot of times you will hear about, well, we have a social contract. Okay? The Constitution is our social contract. Not true. It's a directive from the people to the government. This was not negotiated. What happened was that we had, well, first of all, we had the Declaration of Independence, which President Lincoln considered a constitution in its own right. And we have the, what was it called? It was when the states got together. No, I'll think of it in a moment. But anyway, they got together and they got this intermediate document. And under that document, we had 14 presidents. Each president lasted about a year. Okay? Well, things didn't work out too well. They were very dissatisfied. And so the states decided to review this and see what we can do to fix it. Well, in the Continental Congress, or these representatives got together in Philadelphia, and they kind of cut themselves loose from their mission, and they rewrote it. And when they rewrote it, they called it the Constitution for the United States of America. Okay? No precedent for that, other than they just did it. But that was not enough. they then said, well, we have to go through some steps in order to make it actually work. And the first step was that everybody had to vote on it. The people voted on it, whether or not to accept this Constitution. Then after that, the next step in ratification was the states. If 9 or more states accepted it, then it was a go. Had it been 8 or fewer, it would not have existed. Okay? And by the way, you can read that right in the last section of the Constitution. It's right in there saying what it would take to ratify it. But they did ratify it, and so it was a go. And but George Washington was actually the 15th president, if you count them. But the first 14 were part of the prior organization. But see, it wasn't in the first one. I don't know why I can't think of the name. It's so common. But anyway, in the first one, the states actually came together. They formed this working paper. But in
Articles of Confederation.
that's it, the Articles of Confederation. So they formed the first organization that was solid. They were united and so forth. But then, since it wasn't working out so well, they then formed the Constitution. However, the Constitution was a creation of the people. The preamble says so. We, the people, ordain and establish. Ordain means we're authorizing it. We're ordering it. When we establish it, that means we're actually putting it on paper. We're defining it. So the Constitution is the Articles of Incorporation of this trust organization called the United States of America. And when you look at it that way, it becomes apparent that the United States of America is the world's 7th smallest country. 10 miles square, District of Columbia. That's the United States of America. It's a trust organization. It's not a state. They keep pushing for a state. But see, the problem that the Founding Fathers had was this. They wanted to have an organization that would work because the Articles of Confederation didn't do that job as well as they liked. So they put together this new organization, but they all knew that governments get corrupt. So they had to put limits on it. So one of the things they did is they said, well, let's see. We want a government that's so strong that it can keep away our natural enemies. England, France, Spain, Mexico. Okay, these were all threats to us. They all had their own military, and we were just a fledgling organization, so we had to have some way to counter that force. So we made it strong enough for that, but on the other hand, we didn't want it so strong that it would take over the people. So they put in certain restrictions which are itemized in the Constitution itself. So the federal government operates on the basis of what they have been granted permission to do. So they cannot be entrepreneurial and decide, oh, well, the Constitution doesn't say we can't do it, so why don't we do it? They can't do that. And by the way, having said that, they do that, okay? You look at the welfare, for example. There's nothing in the Constitution that authorizes welfare. There's a responsibility for the general improvement of the country, but not welfare, not Social Security. And by the way, Social Security there was a court case where they said Social Security, if you're making payments into it, that's actually technically an income tax. And if you're taking money out of it, that's technically welfare. And the two programs have nothing to do with each other, except that they set the welfare rates according to the income rates. But the money does not come from Social Security over to the welfare. And this system, just as another little footnote, was approved by the Queen of England. Bet you didn't know that. She authorized it. Contract, I suppose. Maybe we have a treaty with them in which but whatever it is, I do know that it was approved by the Queen of England, Queen Elizabeth.
In which year?
I don't know. When did Social Security start?
When that's when it started.
That so shows
That was after World War I.
Well, whatever. That's just a little note that.
side note.
Yeah, a little side note. That's all. Just letting you know.
Yeah.
Okay.
Another side note. Mexico was not an enemy yet because it didn't exist like it was a state.
The northern half of Mexico is also under the Social Security.
Right. No, I'm saying when the Constitution was established, Mexico
No.
didn't exist yet.
Well, yeah, right. That's true. Then we had the Treaty of Hidalgo. And if you se habla español, ¿verdad?
Yeah.
Yo también. So anyway, the Social Security, you see, there's nothing in the Constitution. Now, there was a fellow by the name of, I think it was Davy Crockett. I'm not sure, but he was a congressman at a part. He died in the Alamo, I understand, but he was actually a congressman, and there's a story written about him, and I'm not sure if it was written by him or not, but it's called Sock Dolliger. Sock Dolliger was a relating of how the congressman was traveling through the United States trying to get votes. And he came to this farmer who happened to be quite knowledgeable about our system. And the farmer challenged him on this idea. There was a proposal before the Congress that they wanted to honor the wife of somebody who was patriotic and died, and they wanted to give her some money. And what the farmer said is that, look, the person can be very deserving, that, we have concern about her and so forth, but there's nothing in the Constitution that says that you can give away the public money. Okay? Therefore, you shouldn't. You mustn't. And he made the point also that, look, if each of you congressmen want to dig into your own pockets and help her out, that's fine. But don't use public money, because there's nothing in the Constitution that authorizes it. So he went back to the Congress. Well, before that, the farmer said, it's because you were favoring that proposal that I'm not going to vote for you. And but if it ended up that he made a presentation to the local community, and this farmer happened to be very, very influential, gathered them all together, and he did win. But what he did afterwards is he went back, after making his speeches, he went back to the Congress and informed the rest of the members, and they turned that down. They did not issue any welfare to this lady. And they were invited to contribute on their own, but I didn't see anything, any record or any statement saying that anybody dug into their own pockets. It was easy to give away the public money, but not give away their own money. So, and to this day, there's still no constitutional provision that I know of. And actually, the Department of Education is pretty well unauthorized. You know, they've passed statutes and codes, but they're unconstitutional. Can't give away the public money. Of course, every country, what one politician said is that it has an average life cycle of about 200 years. They have their revolution, they improve, they peak out, and then when they fall back down, they have another revolution. And it's a couple hundred years. We're lucky. We've been going, what, close to 250 years? Something like that. Yeah. And so, an interesting thing in history is that Greece had a period of time, it was called the Golden Age of Pericles. Also, it was the Golden Age of Greece. Two names for the same thing. And Pericles was an influential politician in Greece. And this was the best of times for Greece. I mean, things were better than they'd ever been before and so forth. The interesting coincidence is that that period of time that Greece was having such a great success was only about 50 years. And during those 50 years, that was a time when corruption developed the most, and then Greece began to fall. Now look at what we got here. We've gone about, like I say, about 250 years. The past, I'd say maybe 75 years, roughly, you've never seen prosperity like you've seen it in the United States. Even a homeless person is better off than most people in the world. You know, what is it? 90% of the people don't even have a house to sleep in. You know, the numbers are terrible. And so there's no precedent here in the United States for thinking that we're immune from crashing. And we're seeing a lot of it now. The judicial system has become quite corrupt. Not necessarily financially corrupt. Well, maybe so. I don't know. You know, we have this bonding process, which goes on every time somebody gets arrested. A bond is created that he doesn't know about. A friend of mine asked a prosecutor one time about CUSIP numbers. Every time there's a large financial transaction, or government, whatever, a number's assigned. If you get a birth certificate, if you look on the back of it, they have a red number stamped. That's a CUSIP number. CUSIP, the word CUSIP, C-U-S-I-P, is an acronym. I can't remember what it is, but basically has to do with transactions. So he asked a prosecutor, what about the CUSIP numbers that are assigned to the court? And he actually had a list of them, okay, of what those numbers were for that particular court session. And the prosecutor said, well, I'm not allowed to talk about that. Also, if a judge uses the word CUSIP, he's subject to a $10,000 fine. So this is very important that you not be informed. Okay? So we have a secret government. And one of the things that is worth reading is to look up the statement by Colonel, I think it's Colonel House. I think his first name is Edwin or Edward. Anyway, Colonel House said to President Wilson that he's figured out a system where people can be contractually obligated, and the government can take control of the people. And by setting up this system that he had designed. And apparently it's been implemented. Social Security is part of it. Anyhow, end of another footnote. Yeah, plausible deniability. If anybody figures accuses him, there's plausible deniability. But then also, that's it. Edward Mandell House. Yeah. I have his quote on the website, by the way. You're right. Absolutely right. Not one man in a million will figure it out. And if he does, he's too busy profiting off the system to want to expose it. Yeah. All right, let's go back to Rome. Rome was a republic. Now, I can simply explain it, probably in fewer words than are here, but the best way to explain a republic is to first explain a democracy. See, in a democracy, everybody argues among themselves on some issue, and then they vote. Whatever the outcome of the vote now gets imposed on the members of the group. Okay? That's a true democracy. Well, they say that, but, you know, there have been pretty good results from democracies as well as bad results. But then the sovereignty is put, like I said, in the group. So whatever the group says, that becomes law. A republic is identical. There's no such thing as a democratic republic. Okay, that's a confusion of terms. Democracy and republic are separate definitions. In a republic, the people do just like in a democracy. They argue among themselves and then they vote. Whatever the outcome of that vote is, cannot be law. It's got to be advice to the people. And the reason is because in a republic, the people are the sovereigns. If some entity could come along and impose its will on the sovereign, that sovereign's not sovereign anymore. Okay? So in a republic, the individual is free to say no. Okay? There's no law above the sovereign. However, if the sovereign injures another sovereign, the other sovereign has certain rights to collect for that. Okay, can sue for it. But if you harm no one, then there's no law that applies to you. So we have laws which are mal in se, meaning just by their own existence, they're bad. Okay, for example, murder is automatically a bad crime. Robbery, okay, assault, those are true crimes. So the other kind of laws, well, they're made up. The legislature makes them up. So in a republic, you are not subject to law. You override the government. You're the creator as one of the people. That's one point. And the other point is that the people are sovereign. And we go back to the California codes. There's 2 codes in California that have almost the exact same wording. They both sound the same, but they're spelled differently. One of them is called the Brown Act. Some people know it as the secret meeting or anti-secret meeting law. The other one is the Bagley-Keene Act. That's spelled B-A-G-L-E-Y. And Keene is spelled K-E-E-N-E, with a hyphen in between them, I think. But the Bagley-Keene Act and the Brown Act both say the people of this state do not yield their sovereignty to the agencies which serve them. So the Supreme Court is an agent of the people. We created the government, and then we gave them the Constitution, and part of that Constitution that we created was specifications for a Supreme Court. So we, the people, are in charge. Well, let's see. Lost my train of thought again.
So if robbery is a crime in California now, or at least in Los Angeles now,
Everywhere.
right?
Everywhere.
If it's under $950 if you break into somebody's house.
Well, that's statutory stuff. Under common law, what would you decide if you were on a jury and somebody was in front of you for robbery?
I'm guilty.
Probably, yeah. So the common law definitely would override the statute, wouldn't it, if it were brought up that way?
So how if we're violated under $900 and the government's doing nothing, then what do we do?
Well, you're actually leaving theory, and now you want to talk of practicality. Okay? So the question is, if somebody robs, like shoplifting is a good example, and it's under a certain value, like $950, is it? Okay. Well, then that is a ticketable, a citable offense. Well, fine. I guess that's the way equity operates. After all, those rules are equity rules. But if it ever becomes a common law issue, you bring a court, if somebody robs you and you sue them using common law procedure, that could be serious jail time. In fact, under the common law, I think it was, what was it? There was something that was, burglary. Burglary was a capital offense, death penalty. If you got burglarized, would you feel like killing them? Sure. So the common law says a death sentence. Well, they give a person a choice. You want to be prosecuted under the common law, or would you like to be prosecuted under equity law? Guess which one they'll choose. Okay?
But if you're the victim of that crime, you can't.
Yeah, if you're the victim, you can appeal to the, I shouldn't say appeal, but you can ask the government to go arrest them and prosecute them, and maybe they will and maybe they won't. But if you actually sued them using common law procedure, that guy just may be in trouble. There is such a thing, that what they call a civil jail. You can go to jail for a civil offense. All you have to do in your lawsuit is ask for it. Okay? You say, hey, what that person did to you is worth so much jail time. That's what you're suing for. You could do that. However, you'll probably get a lot of resistance from all these equity people, the judges that do mostly equity, and maybe they know and maybe they don't know when they're doing common law. So these get into gray areas. The law isn't that tight. Now, in a republic, there's one more feature in a republic. You can delegate your authority, or you could do it yourself. In fact, there was an incident maybe 5 years ago, something like that. I'm not sure, 10 years ago. There was a freeway sign that was badly done. It just wasn't right. And people agreed that it wasn't right. It was generally known. But for some reason, California Road Department, whatever they're called, didn't change it. Typical bureaucratic lethargy, I guess. So what a guy did one time, he climbed up the sign, he got his equipment together, and he repainted it. And there was a big discussion for a while in the newspapers about, well, how can he get away with that? Are you going to prosecute him for that? And it was known who did it. And everybody agreed, hey, he did a good job. You know? Well, I know they didn't realize it, but what he did was he assumed the powers that he had in a republic as one of the people. He decided not to leave it to his agents, and he went out and did it himself. And that's what we're talking about here now, because look at the definition of a court. What is the definition of a court? It is the person and the suit of the sovereign. The sovereign himself files this lawsuit. He just created the court. The court is not a room, although rooms can be called courts. A court, a legal court or a lawful court, is actually a fiction created by the combination of the person of the sovereign and the suit of the sovereign. You put them together, you now created a fictitious court. Okay? And this is called a legal fiction. Legal fiction means that for the convenience of legal procedure, we recognize this fiction. Okay? How long have we been going?
Just an hour and a half.
Hour and a half? Does that, and,
Actual recording, yes.
yeah. Does anybody want to take a break? Short one, 5 minutes, something like that?
If you want, this is just one
No,
hour.
I'm good. I'm
Oh,
good.
okay.
Yeah, well, maybe I'm sadistic. I don't know.
Would you like something to drink?
Who, you or me?
Would you like something to drink?
Oh, I'm good. Thank you very much. I appreciate it. Yeah, I'm good. Not- what dog?
Lucy.
Oh, right there. Oh, yeah. Well, I like those kinds of audiences because they never object.
That's right.
You know, they seem happy with what I tell them. I got the dog outside trained. When I'm approaching, he pops right up. Oh, here he comes. Because every time I pass him, I give him a little pet, you know, and he likes that, or she does. Yeah. Yeah, right, that too. So, anyway, in a republic, in addition to being sovereign and you are your own law, you're also can either delegate a job or do the job itself. And so what I do is on this rule, and these things are, by the way, backed up by the Supreme Court decisions, which you will find on the website. You can be a citizen for some purposes and not a citizen for other purposes. And this is a republic, and in a republic, you have this power.
We're two different hats, right?
It depends on your mood. You know,
And you can turn it off like a light switch.
that's up to you.
You have to file any papers to do that, or you just
No, are you a
make
light
statement?
are you a light switch? No, it's up to you. You know,
I'm sovereign right now.
well,
That's all you
I
say.
declare myself.
you're a pauper. Well, that's your choice. That's like being a citizen. Maybe worse. Maybe better. I don't know. Yeah. Well, the point is that, like that example of the janitor in the store, you know, you're one of the owners of the country. So you can be an owner and act accordingly. Do the job yourself if you want. So when I file a lawsuit, I'm declaring myself as one of the people. The very first sentence in my lawsuit says, I am, and I put my name, comma, one of the people of, and then I name the jurisdiction, like one of the people of California or one of the people of the United States, and then another comma. And in this court of record, claim against the following defendants. Okay? And then I just list the names. I don't bother with job titles, just the name of the individual. Okay? Now, that simple, innocuous statement is devastating to the opposition because you identified who you were. You've said you're in your sovereign capacity because all people are sovereign. Okay? Not citizens, but people. So you say, I'm one of the people of California. You're part of that club that created. And in this court of record, and the court of record is powerful because a court of record has to meet four requirements. Okay? The first requirement is that it keeps a record of the proceedings. The second requirement is that it can fine or imprison for contempt of court. Every court has the ability to enforce its orders. So those are the first two requirements. And you will find those first two requirements listed in Black's Law Dictionary, 5th edition, and later. If you go to the 4th edition and earlier, you'll discover that there's two more requirements. Somehow they left it out of the 5th. The third requirement is that it is proceeding according to common law procedure. So there is a procedure in common law, and you're following it. Now, you can use that procedure to enforce statutes and codes if you choose to, but the procedure is in accordance with common law. Okay? Yeah. Now, that's the third requirement. The fourth requirement is that the tribunal, that's the one who makes the decisions, okay? The tribunal is independent of the magistrate that's conducting the proceedings. In other words, the tribunal makes the decisions. The judge makes no decisions other than ministerial decision. The ministerial decision is like, for example, okay, it's your turn to talk according to the rules. So he directs, he's a traffic director who gets to talk in a courtroom.
What's the tribunal?
Tribunal is the one who does the judging.
That's you.
Is that the
Yeah.
judge or is that the?
Yeah. Well, let me get over this moment of confusion. You don't seem to understand what kings do. Should I put my crown back on?
So what is the tribunal in this situation? In this context, what's the tribunal?
He's a decision maker. He makes a decision.
So in a court of law, you file a suit down in Pasadena court, and you follow this procedure in the court of record.
Yeah.
So who is the tribunal? Are you?
What do you think a king does?
So
Put your mind back.
you're the tribunal in the suit that you filed.
Yes, sir.
Hang on a second. Put your mind back to the 15th century. You have a king sitting on the throne who doesn't know how to read or write. Okay? Only the priests know how to write, which kind of explains the black robe. But you see, the priest was only a counselor. The king made the decision. And tribunal, that term comes out of Rome. It does not mean three. Like tribunals. No, a tribunal is the decision maker. So, and who would make the decision in a king's court?
The king.
Going to be the king, right?
And the person that filed that suit is the king.
Say again?
The person that filed that suit that's named in the very beginning.
Well, that's how you created the court. What a coincidence.
Wow.
But you have to make
Well, that's the theory, as long as you don't have a dictatorial king. But then remember this: we've all been disarmed. Okay, we don't do what's called self-help in enforcing judgments. We used to. The court would make a judgment, and then it was up to you to collect it any way you could. But that's no longer true. If the element of force is present, then you have to delegate it to the sheriff. Okay. Now I realize that is an equity concept, because that's in the statutes and codes what the duties of the sheriff are. But in reality, you were responsible to enforce your own judgment. You went out and collected it yourself. Bring your own army. Okay? Well, we don't allow that anymore. We want force to be properly restricted, properly controlled. At least that's the theory. Okay? Now I know it doesn't always work in practice. That's a problem with any system. But you've got your judgment, and that judgment was made by whom? By the king, the tribunal, right? So now, an extension of this idea is that the court is a fiction. It consists of two parts. It consists of the person of the king and the suit of the king. So, being an artificial entity, a fictitious entity, it has no voice, has no vocal cords. So, how does a fictitious entity speak? And the answer is it can't. So, what the court needs is an attorney to represent it. Okay? Now, an attorney is defined as somebody who represents somebody else. Okay? An attorney represents another entity, be it a human or artificial or whatever. So, the court needs what's called a private attorney. A private attorney is different from a public attorney. The public attorney has his license that he waves in the air saying, the Supreme Court authorized me to represent people. A private attorney only has one customer, not even a customer. He just has one person, whether it's an entity or whatever, that he represents. And so when the court, that fictitious court, makes a decision, then the attorney signs it. Why does he sign it? Because he's a witness to the decision. And as a witness to the decision, he turns around and he has a voice and he tells the world what was the decision of the court. So in our court papers, when we issue an order, we have it in the upper left-hand corner where you